Yeah, the last speaker of this morning's session, Mike Radford. Mike's a reader in law at Aberdeen University, originally employed in academia as a jobbing public lawyer. He describes, and he started teaching animal welfare law more than 20 years ago as a sideline, but it's now taken over his life. Mike's worked extensively with politicians, officials and NGOs, both within the UK and internationally. He's presently a trustee of the Dogs Trust, the PDSA, the University's Federation of Animal Welfare, Humane Slaughter Association, and serves as a deputy chair of the Dog Advisory Council. Mike was appointed OBE in 2008 for his services to animal welfare law. And we're going to discuss unnecessary suffering, a legal perspective, notwithstanding the very welcome emphasis on welfare in the development of public policy relating to animals. The offence of causing unnecessary suffering is the bit that underpins animal protection legislation within the UK. So Mike is going to consider the origins of that, the development, its contemporary meaning, the continuing significance and the relationship with the duty under the Animal Welfare Acts to take such steps that are reasonable to ensure that the needs of the animals are met. So Mike, thank you.
Thank you, or not, as the case may be. I was just sitting there thinking, and two threads seem to come out of the two presentations we've had so far. The first is how different the duties, the role, the obligations of a veterinary surgeon are now compared to, 20 years ago. Hasn't it all got a lot more complicated and multifaceted? And the second thing that's come out is how difficult it is to define concepts in matters involving animals, put them into language which works in practice. Following on directly from the previous presentation, it must have been the best part of 10 years ago. I remember being lumbered with writing a report for the Companion Animal Welfare Council with Bill Swan on the regulation of animal sanctuaries. And Bill did the clever stuff with science on what welfare meant, and I got landed with the regulatory bit. And one of the real sticking points was to try and come up with a concept which would distinguish between hoarders on the one hand, which were considered generally bad, and small-scale rescue centres, or often of which would be just one person or two people, often operating in their own homes and gardens, who, if properly regulated, might be thought to be a good thing, and it was virtually impossible to do. Which brings us to unnecessary suffering, where there is good news and there is bad news. The good news is that I can give you an authoritative legal opinion on what unnecessary suffering means. The bad news is that if you received that advice in a legal opinion, you probably would think it was 250 guineas not well spent. Because the authoritative legal answer to what is unnecessary suffering is, it all depends. Which is why I've ducked out and called this unnecessarily suffering partially explained. What I can do is give you some guidance on the formula to adopt in deciding whether or not something constitutes unnecessary suffering. What I cannot do is give you the answer, because the answer is in your own hands. It is a matter of personal judgment. And the same applies if it's a court that is considering it, or if it is you as veterinary surgeons. It's more complicated than that, because the term unnecessary suffering appears in a number of different pieces of legislation. It appears in a number of different jurisdictions around the world, and it is not necessarily the case that it means the same in every context or is applied in the same way in every context, because unlike you sensible scientists who come up with a theory or a piece of evidence which can then be generally applied internationally, law is, and legislation has two drawbacks. First of all, it is jurisdictional, and the meaning can vary from jurisdiction to jurisdiction. And secondly, legislative draftsmen and draftswomen are like Humpty Dumpty. They can make words mean whatever they want them to mean. So what I shall do is focus on the most important context where the term unnecessary suffering appears in UK legislation, and that is in relation to the Animal Welfare Acts. We now have 3 such pieces of legislation which are of general application. There's the one from 2006 that applies to England and Wales. And Section 4 is the relevant section. There's the Scottish one, which is Section 19, and more recently, the Welfare of Animals Act, Northern Ireland. And at last, the wording is very similar in each. And in each case, the was twofold. First of all, formally to replace the offence of cruelty which had previously been contained in the Protection of Animal Acts, which dated back to 1911 and 1912, and weren't in themselves new law at the time. They were what we call Consolidation Acts. That is to say, they were meant to tidy up the law rather than reform it. So it replaces that. And secondly, the intention was to reflect in legislation the position as it was in law in 2006. And what I mean by the position as it was in law in 2006 is taking account of, on the one hand, what the Protection of Animals Act said, and secondly, crucially, how the higher courts had subsequently interpreted and applied that legislation. Now, just to say something about the origins of this term, unnecessary suffering. When the first legislation was passed in 1822, the way it was drafted was there were a whole list of prohibited acts. Prohibited subject to the adverb cruelly. It was the adverb cruelly that was used. And so in 1822, you get wantonly or cruelly to beat, abuse, etc., etc. In 1835, torture was added and protection was extended to bulls, dogs, and other domestic animals. But the same format of cruelly doing these things applied. And in 1849, wantonly was admitted, and the list of prohibited acts were confirmed as cruelly to beat, ill-treat, overdrive, abuse, or torture any domestic animal. So the issue which the courts faced was, what does this adverb cruelly mean? And the way they dealt with that was and this is the higher courts, in 1863, the English High Court says that cruelly means the unnecessary abuse of any animal. In 1906, the High Court says a long series of decisions have put upon the word cruelty the meaning not only of cruel in the sense of paining the animal, but cruel in the sense that it is unnecessary. In 1825, the court says cruelly could not be better defined than causing unnecessary suffering. The first time it appears in legislation is in a piece of legislation called the Protection of Captive Wild Animals in Captivity Act in 1900. And what they do in 1911, 1912 is they play it both ways. They have the adverb cruelly, but they also refer to unnecessary suffering. So that's the origin. What it doesn't tell you is how the courts will apply this term unnecessary suffering. So far as the Animal Welfare Acts are concerned, and it's now the same throughout the United Kingdom, the Acts apply to vertebrates other than man, which are also within the definition of a protected animal. It's a little bit confusing because there's also protected animals in the scientific procedures legislation. The definition here is different. In order to be a protected animal, it has to fall within one of these three bullet points. These are alternatives. It doesn't have to do all three. Either to be of a kind commonly domesticated in the British Islands, or under the control of man permanently or temporarily. In most cases, it will be clear from those two criteria whether the animal is in or out, but there's a fallback position of an animal not living in a wild state. So, for example, feral cats, which are, to all intents and purposes, looking after themselves, would still be in the legislation, subject to the courts disagreeing with me, would still be into the legislation in the sense that they are of a kind normally domesticated in the British Islands. If it's a wild cat, it would be different. If it's a hybrid, well, that's how lawyers make their living. There are two exemptions, scientific procedures which are being carried out lawfully, and anything done in the normal course of fishing, which is an entirely political interjection. Haven't got time to explain the background, but happy to do so over a pint afterwards. It's an interesting story. The offences are, for unnecessary suffering, are similar in all three jurisdictions. Scotland is slightly different in that there are three offences, three possible grounds of liability. And in my view, and this is not just because I've gone native, Scotland have got it right. The English, Welsh, Northern Ireland, two offences. It's this first one that I have some difficulty with. It says any person may be guilty of an offence if they cause a protected animal unnecessary suffering by an act or failure to act, and they knew or ought reasonably to have known that the act would cause the suffering or be likely to do so. Now, arguably, that imposes a duty on the unofficial bystander to intervene if they see an animal in distress. That would not normally be the position in law. The second liability is indirect liability, where somebody is responsible for an animal but not actually there on site. For example, if I were, instead of being an impoverished legal academic, I earned proper money by being at the bar or whatever, and I had land up in in Northumberland, which I visited once a year to lay waste the grouse, but kept some sheep there the rest of the year but never went near, but employed somebody or had somebody looking after the sheep, I could still be held to account if those sheep were caused unnecessary suffering, notwithstanding that I was down in London. This is the Scottish offence, the extra Scottish offence, which I think is correct. It says any person may be guilty of an offence if they cause a protected animal unnecessary suffering by an act, and they knew or ought to reasonably have known that the act would cause the suffering or be likely to do so. The point being there that there is no liability. If you have nothing to do with the animal, you're not responsible for it, but you go and kick it and break its leg, clearly that is an act of commission. But there is no duty under this provision to intervene if you've got nothing to do with the animal, if you think it is suffering. There's no reference to liability for a failure to act. That's in offence number 2, which is restricted to a person who has responsibility for an animal, not the general member of the public. And again, there's the third offence, which is the indirect one. This responsibility issue, there's lots of provisions in the Animal Welfare Acts which refer to a person responsible for an animal, and that is extremely important because it clarifies the situation in a way that it wasn't clear previously. The owner is always responsible. And one of the things that we should perhaps emphasise to people who thoughtlessly take on responsibility for an animal is that by owning an animal, not only are they taking on a moral duty, but they are taking a really quite complex and extensive range of legal duties for it. So the owner is always responsible at the end of the line, but also anybody else who is in charge of the animal or who is temporarily or permanently responsible for it can be held responsible. So a number of people are liable at any one time, and the issue of children is also sorted out in the legislation. Doesn't prevent children owning animals, but whoever has actual care and control of the young person will also be deemed to be legally responsible for that animal's welfare. Unnecessary suffering itself is made up of three components under this legislation: suffering, necessity, and the mental element, which I'll come to in a moment. Suffering is where you come in. Suffering is a question of fact. And all that means is there is no legal formula, there is no legal definition of what suffering is. It is a question of fact for the court to determine on the basis of the evidence which is presented to it. The legislation does say that suffering can be physical or mental. Clearly, mental suffering is much more difficult to demonstrate, particularly because this is the criminal law, and therefore two things: there is no onus on the defence to prove anything. They generally try to do so, but the onus is entirely on the prosecution to demonstrate they've made out their case. And they have to make their case out. This is a criminal burden of evidence beyond reasonable doubt. That is a very high threshold. At this point, the suffering does not have to be prolonged or substantial, but suffering there must be. If you've got a pile of bones in the corner of a field, you may suspect that the sheep died of starvation, but that's no good for court because you can't establish that beyond reasonable doubt. Similarly, or you can't establish that it suffered before death beyond reasonable doubt. Similarly, if death is instantaneous, there is no suffering unless there's been ill treatment in the lead up to it. But a case, for example, where some youths were on a wall and jumped off the wall, they'd got a kitten, they were aiming to cause it unnecessary suffering by landing on its tail. Either the kitten moved or their aim was poor, and they landed at the other end, crushed the kitten's skull. They intended to cause it unnecessary suffering, but death was instantaneous, so no case. So suffering is a question of fact to be determined by the court. If the prosecution has made out that case, it has demonstrated beyond reasonable doubt that the animal suffered, then the question turns to necessity. And what the legislation, all three pieces of legislation, say is that determining whether suffering is unnecessary includes, so this is not a comprehensive list, but includes could the suffering reasonably have been avoided, terminated is included in Northern Ireland, or reduced. Is it otherwise lawful? Was it for a legitimate purpose? For example, benefited the animal, protected the person, property, or another animal? Was the suffering proportionate to the purpose? Was the conduct in the circumstances that of a reasonably competent and humane person? Now, Parliament has off days. What on earth was it doing coming up with that formula? Well, what it was doing was this. I'm getting the red light, but I'm colourblind for the moment. Ford and Wiley. This is 1880. This is 1889. Ford and Wiley. The case is that a farmer has sending his cattle, horned cattle, off to slaughter, gets a tenon saw and cuts off their horns as close to the skull as possible. There was no question that the animals had suffered. The question was it unnecessary, because you all like to know the result. The court held that it was unnecessary. What is important is the formula that the High Court came up with. They say the amount of pain caused, the intensity and duration of the suffering, and the object to be attained must always be essential elements for consideration. To attain one object, the infliction of more pain may be justified than would ever be tolerated to secure another. So it's a balancing exercise. And they go on to say, and this is pretty modern concept for the judiciary in 1889, the beneficial or useful end sought to be attained must be reasonably proportionate to the extent of the suffering caused, and in no case can substantial suffering be inflicted unless necessity for its infliction can reasonably be said to exist. So we can say that necessity is a two-stage test. First of all, was the suffering caused for an adequate and reasonable object? If the answer is no, then it's unnecessary. But if the answer is yes, that doesn't make it lawful, because there must then be proportion between the object and the means. The problem here is that applying these tests falls to the court, and different courts can go in different directions. The mental element, I will go quickly here so as not to really annoy the chairman. The important thing here is it's not a subjective test. The prosecution does not have to demonstrate that the defendant intended to cause unnecessary suffering. How do we know? Well, we know from the legislation, but prior to the 2006 acts, the courts had told us this. I see no reason for requiring knowledge or intention to be libelled, says a Scottish judge in 1874. In 1889, this is Ford and Wiley again, where a desirable and legitimate object is sought to be attained, the pain caused must not so far outbalance the importance of the end as to make it clear to any reasonable person that it is preferable the object should be abandoned rather than that the disproportionate suffering should be inflicted. And that slide is further examples of the court saying this. Two more recent cases, beginning of the 90s, they came up with a slightly different formula. They didn't overrule Ford and Wiley, it's just a different formula. This is pigs in Hull. These pigs were coming up to slaughter weight, they had septic lesions. Instead of calling in a vet, presumably because the Halls didn't want the pigs to be given antibiotics so that they couldn't go into the food chain, the Halls self-treated and then sent the pigs off to the abattoir where they were picked up by the OVS. What the court says here is, did the pigs suffer? Yes. Was the suffering necessary in the sense of being inevitable? Now that's a pretty high threshold. If the answer is that the suffering was not necessary in the sense of being inevitable, then you ask, would a reasonably competent, reasonably humane pig farmer have tolerated such a state of suffering? The following day, in the case of Mrs. Isaacs had a dog that hadn't been taken to the vet for a number of years and was in a horrendous state. The court says, did the dog suffer? Yes. Was the suffering inevitable in that it could not be terminated or alleviated by some reasonably practicable measure? Well, clearly it could have been. The dog could have been taken to the vet several years previously. Would a reasonably caring, reasonably competent owner have made the same omission? Clearly they wouldn't. So, liability in the legislation is still the subjective test. It's the reasonable person test, and maybe we'll come back to that in questions. And the necessity, what they've done in the legislation is they've implemented the pre-existing case law. Could it reasonably have been avoided or reduced? That's the decision in Hall and Isaacs. Is it was it for a legitimate purpose? That's Ford and Wiley. Was the suffering proportionate? That's Ford and Wiley. Was the conduct in the circumstances that of a reasonably competent and humane person? That is Hall and Isaacs. And just finally, cruelty or unnecessary suffering test is essential, but on its own it is not sufficient. Its shortcomings are its negative. It tells you what you must not do, namely cause unnecessary suffering, but it doesn't impose any positive duties. The focus is only on suffering, and an animal's condition may be inadequate without it necessarily suffering. It's retrospective. The offence only happens once the animal has suffered, and the threshold, the high burden of evidence, beyond reasonable doubt, means that if the owner won't cooperate, enforcement authorities have to stand around waiting for the animal's condition to deteriorate further, so that they are satisfied that they can demonstrate suffering beyond reasonable doubt. So what you need to complement unnecessary suffering is legislation which imposes positive responsibilities, a focus on the quality of life, which is prospective rather than retrospective, and allows early intervention to put things right. And that's what welfare legislation should be doing. Thank you. And
thank you, Mike. Okay, thanks for that. Appreciate it. It's a real hurdle to try and keep on time, isn't it? With so much to say. But questions? Peter.
Thank you. I now know the difference between a vet's brain and a legal brain, I think. We've been discussing with our ethics and welfare experts for quite some time the rights and wrongs of keeping exotics and primates as pets. I wonder if you could clarify something for me. I think you said that under the Animal Welfare Act 2006, protected animal relates to animals domesticated in these islands.
That's one of the definitions.
Does that,
exotics would be under the second one, which is where they're permanently or temporarily under the control of man.
Okay, that clarifies it. Thank you very much.
Lord Trees.
Sandy Trees, House of Lords. A lovely talk, Michael. And can I ask you about this phrase, failure to act, which is different in the English legislation and Welsh from the Scottish? I would have previously, without the benefit of your talk, interpreted that to mean that was to cover a crime of omission on the part of the owner. But you were suggesting it would also cover the responsibilities of a witness, if I'm correct.
Potentially.
So does that mean that anybody walking in the countryside and passing a field and a cow is in obvious distress, if they do not report that, if they do not act, they are guilty of an offence then?
Well, to be guilty of an offence, they have to be convicted by a court, and to be convicted by a court, somebody's got to bring a prosecution. So one would hope that good sense intervenes and the prosecution would not be brought. But there's a very distinct distinction. Sorry, that's stupid. There's a very clear distinction in that the Scottish legislation, by splitting it out, says that any person who causes unnecessary, any person who has not assumed responsibility for an animal may still be guilty of an offence of causing unnecessary suffering if they do an act of commission, and it is specifically an act of commission to an animal which they may not previously have had anything to do with. That distinction is not made in the Northern Irish and English and Welsh legislation. So I think one would hope that it would be for example, if one was out in the country and saw a wild bird which had been caught in some netting, arguably that would be under the control of man. If it had broken its leg, arguably, I'm not saying this is the case because the courts may throw it out, but arguably, by just walking on by and doing nothing, the innocent bystander has committed an offence. Whereas in Scotland, they clearly haven't committed an offence because they haven't done anything positively to cause the suffering. So I think it's neater. I think it's better. In English law, there is no general principle that one has to intervene. If one sees someone in the river waving, there may be a moral duty, but there is no legal duty for the bystander to do anything to get them out. And so I would have thought that the courts would interpret it in that context, this provision in that context. But it's frankly a bit of sloppy drafting, I think.
Question at the back there.
David Main from Bristol. Just following off that bystander thing, but a useful benefit, that English one, is that if a vet comes across an animal, they're not an animal under their care, that they are obliged to do something about it. Then it's in they have their facility, and that's in the RCVS code.
Yes, but that's a professional duty. Whether it's a legal duty is another issue. It is worth saying, of course, that the provision that I put up right at the end there, the reasonably humane and competent person, that anybody before the court would be judged by their peers. So if one is an ignorant lawyer, so far as animal care is concerned, one is judged by the standards of the ignorant lawyer who keeps animals. If one is a qualified veterinary surgeon, who are much more humane and hugely more competent when it comes to assessing an animal's condition, the duty would be more demanding. In exactly the same way that the pig farmers would be judged by the standards of the reasonably competent and humane pig farmer. Where that breaks down, of course, is if animals are being used for a commercial use and the general standards of the industry are low, because the courts are loath to suddenly make a whole industry's activities unlawful. So what it tends to do is say, well, this activity is going on, it's the general standard in the industry, we'll assume that most people in the industry are reasonably competent and reasonably humane, so that's the standard that we'll adopt.
Question over here.
Arguably, of course, David, with farm assurance schemes, this hasn't been tested in the court, but arguably a defendant could be judged, if they were a member of a farm assurance scheme, they could be judged by but the courts may, the only thing that the courts may say, no, we're not taking that into account, is that the press would no doubt pick it up, would no doubt have a big headline that any farmer who was not a member of a farm assurance scheme, the courts had declared to be inhumane and incompetent.
Question over here.
Yeah, Helen Donald, small animal vet. I'm very interested in this difference between England, Northern Ireland and Wales versus Scotland, because in the context of the previous discussion about hoarding, this bystander situation obviously increases and spreads the onus to act in cases of hoarding where suffering is believed to be taking place. I'd be interested to know your views on that. Thank you.
My view on that would be what I always say to veterinary surgeons when I either don't know the answer or don't want to drop myself in it, is that that's a very interesting point that you could take up with professional conduct at Horseferry Road.
Download
Just
the
tell
app.
them Radford suggested it.
Question here.
Thank you. Thanks for a very interesting talk, Mike. It's Rebecca Garcia. I'm representing today here the Association of Government Vets, and I work as a veterinary advisor for the animal welfare team in DEFRA, and I am employed by AHDLA. I was just thinking where you mentioned the three different stages of how courts will assess suffering. I was trying to link that to the example that the first speaker put on to load or not to load. And I was actually thinking that the decision of loading or not loading is obviously clearly linked to the suffering of the animal, the farmer will have different options. We have discussed the farmer leaving the animal alive throughout, but actually within the law he could actually send that animal as an emergency slaughter animal, which means he kills the animal on the farm and sends the body to the closest abattoir or another one nearby. He could also apply the choice of emergency killing, which is actually he just kills the animal and disposes it. Of course, there are different economical interests linked to the three of them. I just wonder if the test you mentioned of suffering, necessity, and mental element would be something that you could see as vets using as a choice. So when you are challenged with this dilemma, whether you could actually go through the different stages and see how would that work. I just wonder if you had a view on that. Thank you.
Yes, although the wording in the transport regulations is slightly different. I think the important thing to understand, and you all know this, but the important thing to say is that one of the things which still distinguishes the professions from the trades is that with tradespeople, there tends to be a right way of doing things and all the other ways are wrong. And what you're paying is somebody who has the expertise to do the job correctly. Whereas the professions, one of the things which distinguishes the professions is the exercise of professional judgment. Now, what is important about that is that it means that all vets, all lawyers aren't required, aren't expected to necessarily come up with the same answer given the same facts. What the test that the courts will apply, and this is one thing that as lawyers themselves the higher courts do understand, is that they will look not for would every vet have come to this decision, but is the decision of this particular vet within a spectrum of reasonableness. If it's off the wall, then clearly out with the beyond the spectrum of reasonableness, then the vet would be in trouble. But they're not looking for a mechanical answer. And therefore, the really important thing, I think, is for the veterinary surgeon to be able to demonstrate that they have taken account of the relevant facts and have come to a reasoned decision. Now, it may not be the same decision that another veterinary surgeon would have come to, but essentially providing it's defensible, then they should be okay.
Are there any further questions? No? One more here somewhere, did I see? Yep. I think we'll take this as the last question of this morning's session.
Hannah Simmons, Nottingham Vet School. I just wanted to ask where fish fall on the protected animals list, because obviously then some of them are not living in a wild state if they're farmed or pet.
As with anything, there's a line to be crossed. Now, clearly a goldfish sat on the sideboard is under the control of man. Fish in an aquarium are under the control of man. Fish in a garden pond are under the control of man. Fish in a 14-hectare flooded gravel pit, probably not under the control of man. Somewhere between the garden pond and the flooded gravel pit, there is a line which the said fish has crossed. I have no idea where it is. And again, that's where lawyers make their money. I mean, again, it would be on the facts, to which extent. What I can say is that it was specifically said in Parliament when this legislation was going through that birds visiting bird tables would never be considered to be under the control of man. However bad the weather was, however reliant they were for that particular bird table, or bird tables in general, they would always be out with the definition. So I hesitate to use the two terms in the same sentence because you probably think it's totally inappropriate, but application of law and legislation does rely on a degree of common sense, hopefully.
Okay, David's just got one point to make, and then we'll have some closing.
I'm going to cheat. I'm going to have two. But one to say that on all the problems we've had on discussions on pig farms, I've never had a pig farmer go against my recommendation over what to do with an animal. And the other thing is, which just came to light there, What about herons visiting my fish pond?
They are not under your control.
The fish are.
Might be.
The fish are, yes, but so what are you saying? You are responsible for the you're protecting. No, I think your fish are probably out of it in the sense that you are not responsible for the herons' behaviour, and herons don't yet come within. Have been given legal. They haven't got legal personhood yet.
Okay, I'm not sure whether the heron is a protected species or not anyway, so we better leave that one for another day. We've had 3 excellent presentations this morning, very enlightening, certainly very thought-provoking, and I think that's been demonstrated by the fact that we're absolutely full up on time, and I'm going to get unnecessary suffering myself if we don't get out for lunch. So I would firstly like you to thank the speakers in the normal way.